For the second part of contracts, we're going to turn to issues involving the performance of the contract. Part one talked about what is a contract, classifying different types of contracts, how do you form a contract, what are the elements of an enforceable contract. And here we're talking more about once the contract has actually been made, what are the rules about performance and discharge and breach and damages and that sort of thing. So we're going to begin with a discussion about performance. All parties to a contract have duties. That goes with the idea of mutual consideration. Everybody in a contract gets something of value, but they also give up something of value. And they have duties they must perform, whether it's to pay money or deliver goods or provide a service. When a party to a contract has completely performed all of its duties, we say that they have legally discharged those duties. And what that means is they're not in breach, and the contract, from their point of view, is over. Now, there's a technical point here. If one party has performed its duties but the other has not, then obviously the contract continues. And here's a term I want you to know, two terms actually. When the parties have completely performed all duties, we say that it is an executed contract. It's finished. No further obligation. But if one or more parties still have not yet completely performed all their duties, we say that it is an executory contract. So that's the term I want you to remember. An executory contract is one that has not been fully performed. So when the parties have not yet completely performed their duties, there's a couple of different scenarios. One is they just haven't finished performing their duties. They're not in breach. The time hasn't really passed yet for performance. They still have time. The deadlines haven't passed. But when it's clear that one party has not performed its duties and they either have failed to perform them and made it clear they're not going to, or the time for performance is passed, and that's when we get into the breach. So here's how I want to approach it. Just like with part one, I have three different scenarios I want to go through and talk about how these duties work and when there is a breach and what remedy generally might someone have for that breach. Scenario number one is a cleaning service, a janitorial service company. There are many of them. Having worked in an office downtown Wichita for many years, the building that we leased, the landlord had cleaning service that it would contract with to come in every night, Monday through Friday, during the night and clean the offices. And that, I think you know what all that entails. And it's very important. And the landlord would pay, I believe, a flat monthly rate for that. So the scenario I'm going to use is that this landlord is IBIS. The cleaning service I'm calling Apex. So Apex promises to bring or send its employees 5 nights a week to the office building to clean the offices. The nature of the cleaning is probably spelled out somewhere. And it's a typically 1-year contract that's renewable, monthly payment, and the landlord promises to pay. So let's say we have the 1-year contract. It began on January 1, and we're now in March. Things are looking pretty good. But then one night, because of some scheduling issues and some illness of some of the employees, not all of the offices in this office building were cleaned. And it wasn't terrible. It's just that some of the trash cans weren't emptied. They didn't vacuum all the carpets. So the next day, one of the tenants complains to the landlord and said, "Hey, we got some trash over here. It's a little bit dirty. Landlord contacts Apex, and says, hey, this isn't good. What happened? They have a conversation. Here's the point. Apex did not completely fulfill its contractual duties. Now, it may have all kinds of reasons, but it did not perform its contractual duties. The question is whether that is a breach. And we're going to go through some discussion later about performance and duties and breach. But this is a breach. It's a very, very tiny breach, of course. But it is a breach. The landlord's not happy. But the landlord says, okay, well, I understand you had some issues last night. Don't let it happen again. Now, if it never happens again, no big deal. But what if it does happen again? And what if it happens a lot? And what if the failure to clean the offices starts to get really bad and really gross? Use your imagination. At some point on a scale, the breach by Apex is so significant that IBIS, the landlord, has the legal right to declare a breach of contract and to terminate the contract, even if it's mid-year. The hard part is to try to figure out how bad does the breach have to be and at what point can they terminate. We'll talk about that. Second scenario, Firestone makes tires, Harley-Davidson makes motorcycles. This is Harley-Davidson's headquarters. It's a very simple, humble company. And they have a contract. Firestone is to deliver tires. And this specific contract, Firestone has promised to deliver, 5,000 tires to a Harley-Davidson facility on or before a specific date. Price is agreed to, so forth. Now, key fact in my scenario, Harley-Davidson specified in the contract the delivery of the tires is to be March 1st. In reality, Harley will not be using these tires at all until at least May 1st. They just want the tires there early to store them so they don't have to worry about it. The Firestone trucks do not arrive on March 1st. Instead, they arrive about 4 or 5 days later. Here's the legal question. Can Harley-Davidson refuse shipment of those tires? Can Harley-Davidson take the position you're in breach of the contract? And because you're in breach of the contract, we don't want the tires, and we don't have to pay you. We'll come back to that. You can see the scenario, though. What's the harm to Harley-Davidson? Yeah, there might be a technical breach, but what's the harm? Scenario 3. We have a small local business that sets up a fireworks stand near Andover, Kansas, in Butler County every year, and orders fireworks from suppliers, and has a contract with a supplier called Big Boom. So the owner of the business is a guy named Vern, and he contracts with Big Boom, and there are going to be 2 deliveries of fireworks. The first is like June 1st, and the second one is going to be July 1st, because Vern knows that every year he's going to have a big run by customers at the last minute. So half of his fireworks are coming July 1st, and that's what the contract states. Well, first delivery, no problem. Second delivery is supposed to be July 1st. No truck, no fireworks from Big Boom. Instead, the trucks show up about 5 days late. Well, by that time, Vern is packing up his tents, and he's lost a lot of money. Is that a breach of contract? Of course. Is it a minor breach, or is it a big deal? It's a big deal. The legal question is whether Vern can refuse to accept shipment of those late delivered fireworks and refuse payment. And the answer to that is yes. And I'm going to do the analysis on that in just a moment. First, I want to talk about this chart that is probably the most important part of this entire lecture. And it has to do with some very complex principles involving performance and breach. So we lawyers like to think in terms of a continuum, 0% on one end, 100% on the right. So basically the complete performance line here is 100% performance, meaning both parties to the contract have done exactly what they promised and 100%. No breach, no problem. That's great. At the other end of the spectrum, by the way, would be 0% performance. There is a concept, and a very important one in contract law, called substantial performance. It's based on the idea that maybe a party to the contract didn't do everything they were supposed to, but they did most of it. They substantially performed. I mean, conceptually, that's not a very difficult thing. What's important to understand is the legal effect of that. And so remember this is very important. When there is less than complete performance, there is a breach. Anything less than complete performance is a breach of contract. The question is, what right does that give the other party to cancel the contract, or when must they accept the breach in the sense that they have to continue to do their own performance? And that's the substantial performance line. So here's how it works. If a party to a contract has provided less than complete performance, but at least substantial performance, there is a minor breach of contract. And this is the key. The non-breaching party cannot get out of the contract. The non-breaching party is still legally obligated to continue its own performance. Now, it would be entitled to recover damages, money, from anything it sustained out of pocket as a result of the breach. That's a different issue. But it still must continue its own performance. If, however, a party to a contract's performance is not even up to the substantial performance line, in other words, it's less than substantial performance, we call that a material breach, which means a significant breach. It's a big deal. And in fact, the term material breach is a legal term of art, very important one. And when there's a material breach of contract, the non-breaching party is excused from further performance, can get out of the contract, and is no longer bound to perform. Now, you need to understand this concept very, very well, so please read the notes or go back over this if you need to. I'm now going to move on to a couple other points based on our examples. Let's start with the cleaning service, IBIS Apex. The first time that Apex messed up and didn't get quite everything cleaned up, some trash cans didn't get emptied and some vacuuming wasn't done, the way to think of it is, would it be fair to allow IBIS to fire Apex because of that in a year-long contract? It's clearly a minor breach. Is it a breach? Yes, but boy, just tiny. It's a minor breach. IBIS really hasn't been hurt at all significantly. And IBIS therefore cannot cancel the contract. Apex is still providing substantial performance. IBIS has to keep paying. Now, if it could show that it was out of pocket any money because of this little minor breach, then that's fine. Probably couldn't. But at some point, if Apex's performance continues to be poor and tenants begin to complain, multiple complaints over time, significant complaints, threatening to not renew their lease, things like that, at some point it would be absurd for IBIS to just have to keep taking that. So the way to think of it is at some point IBIS can take the position, Apex, you are in material breach. We are terminating the contract. We're going to bring somebody else in. We are not paying you anymore. Now, they may end up in court later, but that's the way to think about it. What's difficult is from IBIS's point of view, how do you know how bad is bad enough? When can you pull the plug? And as a lawyer, I dealt with this a few times with my own clients, advising them on it, and it's not easy. My advice to them was, the first time there's been a breach like that, a minor breach, make sure you notify the other party that they messed up, they're in breach, but let them know that you are going to work with them and that you expect them to do better and hope they will do better. In other words, you give them a do better. Once you've done that 2-3 times, If it still continues to be a problem and they're not doing better and they're not coming through like they promised, you probably then are justified in terminating the contract. And I can assure you in court later, the judge will be impressed that you gave them an opportunity to correct the problem. I mean, it just looks reasonable and fair. And by the way, I teach ethics. It is the right thing to do, because nobody's perfect. The second scenario, Harley-Davidson versus Firestone. If the delivery is a few days late, it is a breach. It's a minor breach. But if Harley-Davidson is not going to use the tires for another 2 months, obviously there's not a lot of harm to a late delivery, is there? It would definitely be a minor breach. Firestone definitely substantially performed. Therefore, Harley-Davidson could not reject the shipment, would have to pay for the tires. The most it could do would be to demand a credit or a discount by Firestone if Harley-Davidson could show that it was out of pocket anything as a result of the breach. And one example I've used is, suppose that the contract called for delivery of the tires to Harley-Davidson on a weekday where they have many employees on hand to unload the tires, but the trucks show up on a weekend and Harley-Davidson had to pay overtime to some employees to unload the trucks. Okay, the overtime might be an expense, a cost, what we call incidental damages. Vern versus Big Boom. I don't need to spend a lot of time on this one. I think you can see that that was very definitely a material breach. It cost Vern a lot of money. But note the difference. With Harley-Davidson versus Firestone, it's a 5-day late delivery. With Vern versus Big Boom, it's a 5-day late delivery. Every case is different. It depends on the facts. And in Vern's case, he very definitely can take the position it's a material breach. He can very definitely refuse to pay for the fireworks. In fact, remember this. This is one of the rare cases where someone could not only refuse to pay for the fireworks. I think Vern could sue Big Boom for breach of contract and get what's called consequential damages, which means in this case lost profits. Actually, it's very rare for a court to allow a party, a plaintiff in a breach of contract case, to recover lost profits. But this is, I think, one of those rare cases, and we call it consequential damages. What if Harley-Davidson wanted to take the position in the contract that it negotiated with Firestone that they want those tires delivered by March 1st? They have their reasons, and by golly, if those things are late at all, they want to take the position it's a material breach and they can reject the shipment. You can do that under the UCC, but to do that, you have to put in the contract that delivery date is a matter. What you say is its time is of the essence for delivery date. And when you have that, any late delivery at all makes it a material breach. Now, if you're wondering, well, does Firestone have to accept that? No. In a negotiated contract, Firestone could say, no way, we're not going to agree to that. That's crazy. But if Firestone agreed to that language, time is of the essence, then a late delivery would mean material breach. Now, I call this defenses to contracts, and they are technically defenses. But the way to think about it is when someone is sued for breach of contract, there are various defenses they can raise to argue that, well, either there really never was a valid contract in the first place, or something happened that voids the contract, and therefore they are not liable for breach. So it's from the defendant's point of view, it's a way of fending off a claim for breach of contract. I'm going to talk about mistake and conditions on separate slides. Let me go ahead and just tell you a little bit about fraud. I covered fraud and torts. Fraud is a tort, but it is also an argument used in contract cases by defendants to say, I'm not liable. The best example would be where the defendant failed to pay for, let's say, a motorcycle, bought a used motorcycle from somebody, and didn't pay for it in full. And the reason was because the motorcycle had something seriously wrong with it, and the buyer feels the seller lied to them about the condition of the motorcycle. There's something like that, where they feel that the party being sued feels that they've been lied to, and fraud was committed by the plaintiff. Well, that one's pretty straightforward. You know, if the plaintiff committed fraud and deprived the defendant of the benefit of the bargain, yeah, they can get out of the contract. But let's talk about mistake, and we'll talk about some other kinds of defenses as well. Here's the memorization part about mistake. A unilateral mistake, general rule, is not a defense to an enforceable contract. Unilateral, again, means one party. A mutual mistake, meaning both parties were mistaken about a fact, is a defense to a contract. The best way to explain this is through example. This is a real case that was filed in Wichita. The city of Wichita over the years has had a number of different sculptures, pieces of art displayed on city property. And sometimes they take them down and sell them and store them and all kinds of things. There was a sculpture, and if I remember right, this one was somewhere around Maine and Kellogg. It was called Upright Form V, very original title. And it was displayed for a while. And at some point, the city took it down, threw it in a warehouse, considered it to be junk, and occasionally holds auctions to sell off some city property. This particular sculpture was part of that auction, and it was sold at auction for $287. Only one person bid. His name was Matt Cuellar, and he got it. Later, the city learned what Matt knew all along, that this particular sculpture was by a famous artist, and its market value on Antiques Roadshow on PBS was about $30,000. Matt got a pretty good deal. Well, the city of Wichita, don't get me started about the city of Wichita, some of the things they do, but the city of Wichita found out about the real value of the sculpture after the auction and notified Matt that he was, in other words, they demanded him to return the sculpture. They were going to give him his $287 back. And the city sued Matt, which is, I think you can see on the face of it, pretty crazy since he got this at a public auction. The city's argument was there was a mistake about the artist and therefore a mistake about the value. They would never have put it up for auction and sold it for $287 had they known the real facts. Matt's defense was, yeah, but that's a unilateral mistake. You were mistaken. You didn't do your homework. I knew it was valuable. I bid in good faith. I got the high bid. Your problem. And the court said, yes, this is a unilateral mistake. Only one party was mistaken. Therefore, there is no defense to the contract. Therefore, Matt gets to keep the sculpture. Now, statute of limitations is another defense that can be raised. Every cause of action has a statutory limit for when it can be brought. I don't talk about this a lot for other causes of action, but in Kansas, for example, there's a 2-year statute of limitations for negligence. And there's different statutes of limitations for property causes of action and other things. For contracts, here's how it works. The statute of limitations for breach of a written contract is 5 years in Kansas. For oral contracts, it's 3 years. But that 5 years and 3 years respectively runs from the date of the breach, not from the date the contract was signed. So you can have a situation where the contract was made in 2005, but wasn't breached in until 2015. The statute of limitations doesn't expire until 2020. So that sometimes confuses people a little bit. 5 years is a long time. It's one of the longest statute of limitations that Kansas has. The rationale, of course, the difference between the 5 years and 3 years is that because written contracts are in writing, there is evidence that remains, we can look at it, and that's more reliable. Oral contracts, they're not as reliable, so we're going to give a shorter time frame. Although 3 years is still a fairly significant amount of time. Now, if you're wondering, or even if you're not wondering, what makes a written contract? What's the key? Especially in an age where we do things by text and email and all kinds of different things that are in writing and can be copied and saved. What is a written contract? Well, it turns out it doesn't have to be very fancy. Best way to think of it is it has to be something that is preserved, can be copied and preserved to present in evidence later, and signed by the parties, or at least the party that's being sued, with the key terms included in the document or the text or whatever it is. In other words, it's a pretty broad definition. Real case, I want you to remember this. A man didn't have much money, and he had a wealthy sister. And his wealthy sister was elderly and very generous, and he went to her and said, "Sis, can I borrow some money?" And he would ask for like $6,000, and she would write him a check for $6,000, and he would go deposit it. And he did this on several occasions over the course of about 2 years, totaling about $24,000. Now, the woman, the sister, was wealthy, didn't need the money, wanted him to pay her back, but she was nice and she figured he needed it more than her. But then she contracted a terminal disease, and close to her death, she said to her 2 adult daughters, "You will be handling my estate after I'm gone. I need to tell you something." And she told him a story about loaning money to her brother, and said, "I never really worried about it. He's in breach. He never paid me back. Deadline's come and gone. I didn't care, but now my money is your money and my grandchildren, and I care. You should go after him as executors of the estate and make sure he pays it back." After she passed away, the 2 daughters were the executors of the estate, and they hired me to sue him for breach of contract. He had not paid back 1 dime. One of the defenses that his lawyer made, was statute of limitations. It turned out that we filed the lawsuit more than 3 years after the breach, but less than 5 years. And if you're wondering why I took so long to file the lawsuit, it wasn't anybody's fault. By the time that Mom told her daughters about this, it had already been, I think, 3 years. So the issue for the judge was very simple, the first issue. Was this a written contract, and therefore we were still in court, or was it an oral contract, in which case summary judgment and case is over? My argument to the judge was, "Judge, what does it take to make a written contract? For each of the loans, there's a check, a piece of paper. She signed it. He signed it when he deposited the check. Look, his signature's on the back. In the memo section of each check, it says loan and a due date. That is a written contract. We've got the amount, both parties, the signatures. It says loan, we have a due date. This is a written contract." And I did have a case from Missouri that had held the same thing, which was not binding precedent, but it was pretty persuasive because the court was only about an hour and a half from Missouri. Obviously, the other attorney argued otherwise. We won. Judge said written contract. We went to trial. We won there too. The guy was lying. When I asked him, "Why didn't you pay this money back for the loan?" he said it wasn't a loan, it was a gift. And of course I pointed out that the check said loan. And he said, "Oh yeah, well she just wrote that down because she didn't want her daughters to know that she was giving me the money." And in ruling on it later, the judge said he found this man's testimony to be incredible, which was the original meaning of that word. In other words, not truthful. Condition is another thing that can be a defense to a contract. The best way to explain this is sometimes when people are making offers and negotiating, one of them will suggest or propose a condition be placed on it. In other words, I only have to go through with this contract if something occurs or if something does not occur. And really, this is the best example, the one that most of us will deal with at some time or another. And that is when you make an offer to buy a house. Let's say the seller has, and you and the seller have negotiated a price for $150,000, but your concern is that you really can't come up with $150,000 unless you sell your own house or current house. So you put a condition in the offer. I offer to buy your house for $150,000, conditioned upon the sale of my current house by March 15th, and upon my being able to qualify for financing to get a mortgage. Now today, mortgages can be obtained in about 5 minutes. In the old days, it took weeks. This second part is not as big a deal as it used to be, because you can get pre-approvals and things. But the point is, if the seller accepts this offer, the seller is doing so knowing that this thing can fall apart. That if the buyer does not sell his house by March 15th and does not qualify for financing or then there's no deal. It's really important when you're negotiating to see what conditions the other side is making, and if you need to put any conditions in, that's important too. Again, I'm often asked, do I need a lawyer to sign or write a contract for me and those kinds of things? Well, I have seen situations where people didn't know about conditions and got themselves in a real bind because they're trying to do it on the cheap, on a napkin, so to speak. You've got to make sure you know how to protect yourself with proper conditions. Accord and satisfaction is a legal defense to a breach of contract. It's the best way to explain this is through an example. And this is a real example based on a client and a case I had. What happened was we represented a company that sold housing materials to contractors and others. And I did a lot of work for them, and it was not uncommon for the general contractors to not pay them in full, or the subcontractors. And so one day I got a call from the finance guy of this company who said, all right, I got a situation. We have a contractor that owes us $30,000, and he hasn't paid it. And his position is he's not happy with some things that we did, and he doesn't think it's worth $30,000. In this case, my client was the subcontractor, I should point out. And he's only willing to pay, $15,000 or whatever. And we feel we did a good job and we should be paid in full. Okay? That happened all the time. He said, I just got a check in the mail from this guy for $20,000, I think it was. And on the check, and also I believe in a letter, he wrote these words: endorsement of payee will constitute a receipt in full when check is paid. And his question to me was, if I deposit this check in our account, and Lord knows we could use the cash right now, I seem to remember from somewhere that we may not ever be able to go after him for the other $10,000, that we cannot legally take the position that this is partial payment. And I said, that's right. It's called accord and satisfaction. He has placed a condition, actually, on the check. It's an offer to settle. And what he's doing in that language is saying, if you cash this check, you are accepting a settlement of a disputed amount for $20,000, and you can never come after me for the $10,000 difference. And I said, therefore, you have two choices. You either cash a check and kiss $10,000 goodbye, or you return the check to him, get nothing right now, and then continue to pursue a claim against him. And that's what they did. I want you to remember something else potentially for a quiz. This is a unilateral contract. What the contractor was doing is saying, if you can't deposit or cash this check, we have a settlement. And that is technically a unilateral contract. Sometimes the parties to a contract realize that they just need to break up. They need to go their separate ways. And sometimes it's proposed by one side, sometimes they just come to that understanding between them. And it's called discharge by agreement. And I mentioned pro athletes because this happens quite a bit. An athlete has 5 years left on a contract. The team could take the position that he can't go play for another team, but he wants to go play for another team. And they get into a big dispute. And sometimes the team just says, all right, we're going to release you. But in return for that, we want some consideration. And when it's a discharge by agreement, technically there needs to be new consideration. So what often happens is the athlete buys out his contract. Happens more often probably than people realize. So discharge by agreement, mutual agreement, generally speaking, the courts recognize that. It's a fairly complex issue in reality. Now, when there is a breach of contract and a lawsuit is to be filed, there are several different remedies that the plaintiff can seek. The big one, of course, is damages, and I'll get to that in a moment, meaning money. But there are some non-monetary remedies, which we call equitable remedies. And I'm going to go through them fairly quickly, but they're important. Rescission is actually a fairly common equitable remedy. In a rescission case, the plaintiff is asking the judge to order or rule that the contract is legally canceled. Sometimes a party takes the position with the other party that, hey, I believe that you're in material breach and we don't have any further obligation, but they get a little bit cold feet. And so then they go to court to say, Judge, will you please say for the record that we were right, that we have a right to cancel this contract? Rescission means cancel the contract. In a case of fraud, when somebody buys a product and feels they've been lied to, rescission is a fairly common remedy for that. They want to undo the deal. They want their money back. Specific performance is the opposite, of course. It means you're asking the judge to order the other party to perform. The best example for this is when you have a contract to buy a house and you have a closing date and you're the buyer and you're ready, willing, and able to perform and you're going to have the money, and at the last minute the seller backs out. They don't have a good reason. They change their mind. That's a breach. But if you were to sue them for damages, what good does that do you? Number one, they still get to keep the house and you wanted the house. And number two, what are your damages? Monetary damages. They're going to give your earnest money back. And there are, a few other houses in Wichita you can go buy. So what are you out? In our system, we take real estate very seriously. And so this is a good example of how specific performance works. You would file a lawsuit for breach, show that they had no good reason to back out. And you're asking the judge to order them to close, to sell you the house. Reformation is an equitable remedy where the argument is there's a mistake in the written contract, an honest mistake, typo, whatever. And you're asking the judge to reform the document, to sometimes we use the term blue pencil it, to edit it. And then, of course, there's damages. Most of the time when people sue for breach of contract, they're suing for damages. They want money. I'm going to go through these fairly quickly. Compensatory damages means to compensate the plaintiff. The general measure of damages in a contract case is the difference between the contract price or value and what actually happened. It's not a windfall. I mentioned this with the bicycle example. And a lot of the time, especially when it comes to the sale of goods, it's just the difference between the contract price and what the person actually was able to sell the goods for. To compensate the plaintiff out of pocket is probably the best way to explain that. I mentioned consequential earlier. Consequential damages are a little broader than this in reality, but lost profits is the best example. It's in addition to. the contract price. Vern lost profits on the fireworks issue. It isn't just that he had an invoice to pay. He can just decline to pay that. He actually lost profits, and that is one of the rare cases, I think, where he could get those. And then there are liquidated damages. Liquidated damages has to do with a situation where parties in the contract that they originally signed had a provision that in the event there is a breach, damages will be difficult to calculate. Therefore, we're going to go ahead right now in the contract and specify what those damages will be. Again, often it's best to explain by example. Probably the best example is construction cases, these large public construction cases involving highways and bridges. When the project to widen Kellogg, which started in the 1880s, and I think the last time I checked will be done by 2060. I know I'm being sarcastic, but I grew up in Wichita. This has been going on a long time. It's complicated. On one of those phases, there was a contract that provided for a completion date by the contractor to open the highway back up of, let's say, June 1st. And it provided that for every day the contract or the project was late, in other words, went past June 1st, the contractor would have to pay the city $3,000. That'll get your attention. It also had a provision that for every day the project was early, the contractor would get a bonus of $3,000, which I thought was fair. And I worked on a big construction liquidated damage case once upon a time where it was my client that was at fault, and my client had to pay $3,000 a day times a month and a half, which is quite a bit of money. They weren't happy about it, but these can be a very effective way. And part of the issue there is how in the world could you ever calculate the actual damages to the city for a highway being late? So liquidated damages work very well in that situation. Now, attorney fees aren't technically damages, but they are often, or they're certainly a cost. And this is just memorization. I may have mentioned this early in the semester. The American rule, and that's what it's called, is that in a lawsuit, both parties pay their own attorney fees. That's the general rule. It's not a winner gets reimbursed rule. That's the English rule. The English rule is the winner gets reimbursed its fees by the defendant, the other party, I should say. But in the American rule, both sides incur their own fees. But that can be, there are some exceptions. One is sometimes by statute, but what I want to talk about here is where the contract itself says that if the parties get into a lawsuit later, the losing party will have to reimburse the winning party its attorney fees. Now, I want to talk, here's a practical point. This is a big deal. Many times in my career, I would have a client that wanted me to sue a business. And, let's say they had shipped product, and this actually happened several times. One client in particular, they would ship product, $50,000 worth of product, and the other side wouldn't pay. And I remember one time they said, I guess we need to sue them for $50,000. And I said, okay, if they contest this, we may have to go to court, actually go to trial, and you'll have to pay my attorney fees, and there'll be costs. And they said, well, how much is that going to be? And I said, I don't know, $20,000 minimum. And they're like, $20,000. So they breached the contract. They owe us $50,000. They don't have a good argument. And we're going to have to incur $20,000 to get $50,000. I said, yeah. What about our attorney fees? Nope. Because your contract doesn't have a clause that gives you attorney fees. And then they said, you mean we could have put in our contract a provision that in this situation we get the $50,000 plus our attorney fees? And I go, yes. Duh. And they felt kind of silly. Well, what if they had that contract? Here's the difference. When I make a demand on somebody for not paying $50,000 to my client, they've already stalled for months. What they're hearing is, I'll never have to pay more than $50,000, so I'll just try to settle for something less than $50,000. If there had been an attorney fee clause in that contract, then when I make demand, what they're thinking is, oh my gosh, we may have to pay $50 and another $20 for their attorney fees. It completely changes the dynamic for settlement negotiation. There is an automatic, it's called a defense, but it's actually more of an automatic thing, that in some cases the defendant, the plaintiff, the good guy, the plaintiff is required to mitigate its damages and has to show the court that it has done so. And it can sound a little crazy. The best example is the commercial lease example. Tenant moves out, 5-year lease, 3 years left on the rent. Landlord's not happy about it, sues the tenant for 3 years future rent. The landlord has to show the court that it has made good faith effort to re-rent the facility to minimize the amount of rent that the defendant will have to pay. And I've been involved in lease cases where this has been an issue. I've been involved in employment cases where this is an issue. Anytime somebody sues an employer for wrongful termination, the judge wants to know, have you looked for another job? And if you dilly-dally say, no, not really, Judge. I've been sitting around for 2 years playing video games hoping I'd get a big windfall. The judge's going to be, too bad. I'm going to assume that you could have a new job with the same salary within 2 months. I'll give you 2 months wages. It's a very serious issue. Interestingly, the public policy behind this is we're not trying to help the defendant. We don't like having dark buildings, meaning non-productive real estate. We don't like having people sit around for 2 years playing video games. We want them being productive out there working. Waiver of breach. As you might know, sometimes you're asked to sign a waiver. You know, if you go bungee jumping, they may ask you to sign a waiver that you can't sue them. You assume the risk. And there are lots of these examples. Many loan contracts address the issue of what happens if you miss a payment. How does that work? So the thing to understand, by the way, on your loan payments, if you miss a payment and they don't sue you, and then the next time you miss a payment, you want to make the argument, you can't sue me because you waived the right to do so. That won't work because those loan agreements almost always have something that says they don't waive the breach just because they let it go once or twice. Now I'm going to kind of simplify this this topic here a little bit from what I used to cover. Contract rights can be assigned. A party has rights to a contract and obligations, and the general rule is that a party can assign its rights and duties and everything to a third party. And I'm going to give you a simple example here in just a moment. When that happens, the assignee steps into the shoes, so to speak, of the assignor and is obligated to the same terms of the original contract. A sublease is a little different, and I think to contrast assignment from sublease, I think the best thing to do is to give you an example. It's based on a real case that I worked on. I worked on a lot of cases. That's what happens in 20 years. All right, here's what happened. There was a factory building. I'll use initials. A was the landlord, owned the building. B was the tenant. A manufacturing company leased the building from A, 5-year lease. After about 2 years, B just moved out. I guess they ran into financial trouble. By the way, A was my client, the landlord. And B just moved out, left it vacant, and then sent a letter to A saying, we're out of business, we're moving. Don't worry, we have assigned the lease to C, another manufacturing company. Have a nice day. C now moves in and starts paying the landlord the same rent, because the way assignment works is that the assignee, in this case C, steps in and is obligated to pay directly to the landlord here the rent. and all the other terms of the original contract apply. Now, let me explain sublease, how it can differ. In that particular example I just gave you, it was a true assignment in which B basically said, we have rights under this lease, see attached, we're assigning it to you, C, and now you step in and we're gone, see ya. The general rule in Kansas is that unless the contract has other restrictions on assignment and sublease, the parties to the contract can assign without, and the other side can't do anything about it. It is also the general rule in Kansas that if a contract completely prohibits assignment and sublease, that is not enforceable. That is a violation of public policy. What Kansas does permit is to have a clause in the contract that assignment and sublease can be restricted in some situations. In the case I'm telling you about, the lease said that tenant shall not assign or sublease without landlord's A, prior written consent. So when B assigned the lease to C, it was required by the contract to contact the landlord and say, all right, we're moving out. Here's who we are proposing to assign this to. Do we have your written consent? And if landlord consents, then B is excused from all liability. And then C is now obligated on the lease. If the landlord says no, then B is going to have to find somebody else. Now, there have been cases where the landlords were completely unreasonable and said no to everybody. That's a whole different situation. And just to finish the point about sublease, the difference with a sublease is B could have said to C, all right, we have this lease. We're going to stay on the lease, and we, B, will pay landlord for future rent as it comes. But you, C, will sign a separate lease with us, and you can have different terms, and you can have higher rent. And that's the difference between assignment and sublease. The end result is basically the same. B moves out, C moves in. So that's how an assignment works. To finish the point about this particular case, I, as an attorney for A, sued both B and C. And because B did not get landlord's written consent, B was liable for the future rent. But then so was C. They are both liable in that particular situation. Again, if B had gotten landlord's consent, then B would have been excused from liability, and then C would be responsible. And the term novation actually means where B in that situation would get landlord's permission, consent, and also get landlord to say, I completely release B of all further liability under this lease. Third-party beneficiary, the general rule is only the parties to the contract can sue for breach. One exception is if it's clear that at the time the parties made the contract, they intended to benefit a third party. And I know that may sound a little strange, but it does happen where the parties actually had in mind trying to benefit a third party. And again, example is probably the best way to explain it. Real case, husband and wife were getting divorced. They entered into a contract, a property settlement agreement, which was a binding contract, and in it, the husband agreed to pay the college tuition for their minor daughter when she turned 18. Well, she turned 18 and dad refused to pay her tuition. Well, the daughter wasn't a party to the contract. And mom didn't sue. So the daughter files a lawsuit against dad, breach of contract. Dad's defense was, but you, daughter, weren't a party to the contract. And she said, but I was an intended third-party beneficiary. And the court said, yes, she was. And she won. I'm going to finish up this part 2 with a briefer discussion than it deserves on non-competition agreements. This is really important for lots of reasons. Some of you have already signed non-competition agreements with your employers. Many of you will at some point in the future. They are used now in lots of situations. Most accounting firms require them. If you work at Verizon or AT&T stores, you're going to have them. There are just a lot of situations. As a lawyer, I worked on quite a few non-compete cases. I wrote non-competition agreements. I'm not a big fan of them, and that's putting it mildly. But let me explain what they are. There are two types. The first is a sale of business. When the Carney brothers sold Pizza Hut to Pepsi many years ago, and I guess you know that the original Pizza Hut is on our campus. It used to be at Kellogg and Bluff. They signed a non-compete with Pepsi that they wouldn't go into the pizza business for X number of years. Well, when X number of years passed, one of the Carney brothers was on national TV saying, I'm one of the founders of Pizza Hut, but I think Papa John's makes better pizza. Well, the reason was he was then the largest franchisee for Papa John's. That's how non-competition agreements work. It had expired. But the one I want to spend most time on is employment, because that's what's going to affect you. An employment non-competition agreement is, the concept is you sign an agreement as an employee that after you terminate your employment, in other words, when you leave the company, you will not compete directly with your employer for a certain period of time within a certain geographic area. This is a sample non-compete. Again, I used to write these, and they're written many different ways. But you need to know how these work. Employee agrees that while he is employed with Atlas, Inc., and for a period of 2 years after termination. So what this is saying is after this employee leaves Atlas, he or she cannot compete for 2 years. Note what this says. After termination by either party for any reason. The question that comes up is, okay, if I quit, I get it. I understand that they can't, that I shouldn't compete. But what if they fire me or lay me off? The Kansas Supreme Court has held that with that language, termination by either party for any reason, they can fire you and they can still enforce it. They've thought of everything. Employees shall not, without prior written consent of Atlas, engage in any business activities in competition with Atlas in Sedgwick County. And then it goes on to define what business activities include. So this one is 2 years, and geographic area is Sedgwick County. This one's easily enforceable. It's very reasonable. The Kansas Supreme Court has held in one case that 3 years was reasonable. We know that 3 years is okay generally. There are cases where they've upheld statewide. I worked on a case that was nationwide once, and that was allowed by the judge because the very unique nature of these competitors. There were only 2 or 3 nationally. Here's the takeaway. I've heard over the years many times people say, well, these things aren't enforceable. I've had employees tell me this. I've had employees sitting in my office who are being threatened with a lawsuit or have been sued for breaching a non-compete. One guy one time, I was like, well, why did you breach the non-compete? I mean, it's pretty clear you can't go to work for a competitor, in which time you just did. I didn't think they would enforce it. Why didn't you think they would enforce it? Well, my cousin, who's a lawyer in Texas, said they're not enforceable. Is your cousin named Vinny by any chance? And I just couldn't believe it. I said, but you're in Kansas. They're very different from state to state. Here's something to remember. The state of Oklahoma, by statute, these are essentially illegal. In Texas, they're not favored. In Kansas, they're very much favored. And I've heard some lawyers in recent years say that the Kansas courts are getting to where they don't like these very much. Well, I'd like to meet those judges because I never met one. I worked on quite a few non-compete cases, and everything I saw was the courts really like them. So you better take these things seriously when you sign them. I had one guy who was a doctor who came to me and said, I violated my non-compete, and now the clinic is threatening to sue me. In fact, he had already started building a building across the street. I said, why'd you do this? I didn't think they'd enforce it. Well, guess what? And I had to negotiate a buyout of his non-compete, and he paid, I think it was $40,000. So please take these things seriously. So the last slide, and this is really important, what factors does the Kansas court look for in whether to enforce them? Number one, does the covenant protect a legitimate business interest of the employer? In other words, if the purpose of the non-compete is simply to avoid competition, no, that's not a good reason. And this is the only one of these factors that I've seen the courts occasionally take the position that the non-competition agreement was invalid. But it's only in rare cases. What is the legitimate business interest of the employer? Trade secrets, customer list, pricing list, business strategy, things that the public doesn't know, that the company has spent quite a bit of money training you on specific things that would be really devastating to them if you went to work for a competitor. It's really not all that hard for the employer to prove, number one. Number two, does it create an undue burden on the employee? Yes, every time. I have never seen a court in Kansas, a case I've worked on or case I've read, who even considered number two. They say it, but they don't consider it. Of course, they have to move. One case we had, 7 doctors had to move to Kansas City from Wichita. I would consider that undue burden. Does it injure the public welfare? There have been a few cases in Kansas where the courts did look at this. The argument that, well, my patients, these were doctor cases, are now going to have fewer options in a small town, and they have to drive 100 miles to come to me. And occasionally the courts will look at that. Now, this is really important. Are the time and territorial limitations reasonable? The court will not throw out the non-compete if they think that time is too long or the territory is too big. What they do instead, and this is really important, is blue pencil it using the equitable remedy of reformation. And we have quite a few cases in Kansas where the courts have reduced the time limit or reduced the territorial limits. In one case in Kansas City, I think it said 30 miles from that doctor's office, and the court said that's too big, 5 miles. Or maybe in a couple of cases they've reduced it from 4 or 5 years down to 2. So that concludes Contracts Part 2.